Okay.
All right. All right. Here we go. In three, two. Hello. Glad to have you on New York's Asset Protection Roundtable, a three pillars of protection program. I am Ben George, joined as always by Ted Alatsis, attorney and counselor at law over at the Alatsis Law Firm there in Brooklyn, New York. Ted, how you doing today?
Doing great, Ben. How are you?
I am doing very well, and I'm looking forward to our conversation today on trusts. I know the topic comes up all the time: trust versus will. What's better? What should I choose? And I'm sure you go through that all the time with clients. But we really want to hone in on the trust today and really talk about funding the trust because really you can set up the trust, but until you actually give instructions and put everything in there, your job's not done, right?
That's exactly right. And a lot of times what happens, and we see this all the time, is people come in here and they've gotten trusts done in other law firms, and they come in and they look beautiful, but nothing's been transferred into the trust, so it's almost useless. So yeah, absolutely, it's one of those things that people seem to forget and don't realize that needs to be done.
So that happen that's that so that actually happens frequently. I mean, maybe not frequently, but you do see that fairly commonly.
Yeah, yeah, it happens a lot more frequently than it should. A lot of people think they save money on the on the back end, for example, so they don't necessarily engage the services of their lawyer to assist them with the funding of the trust, and so they just get a series of documents, or they do one of these do-it-yourself trusts, and same thing. They prepare the trust, they think they're done, but they don't realize that they haven't completed the entire process until everything goes into the trust.
Very good. So if you have questions about a trust, today's episode hopefully will lay out some of those and break it down for you and some good information. Hopefully, if you're thinking about a trust and really how to complete that process. But again, if you have questions, I encourage you first to log on. AlatisLawFirm.com is the website. You can schedule a time to meet with Ted there, schedule a consultation right there through the website. There's a button right on the front, or you can call this phone number 718-233-2903. If you have questions about what we discussed today with the trust and you want to follow up with anything specific to your situation, or maybe you want to kind of follow up with something that's happening with your trust and maybe you want to get Ted's insight on that, again, encourage you to call 718-233-2903. So as we talked about, setting up the trust is a great way to protect your loved ones after you're gone. However, just signing the legal documents is only half the job. So you not only have to establish a trust, but you have to make sure your trust will actually control and protect your assets the way you want. So let's just start off, Ted, here with funding the trust. What exactly do we mean when we say fund the trust?
So rather than go into the technical jargon, actually, let me give you a little bit of an example of kind of what we're talking about. So think of your trust as your roadmap or your plan. Okay. And we liken it to one of those old radio flyer wagons, those red wagons with the handle in the front. If you recall from your long lost youth, the trustee is the person who's pulling the handle. Okay, and the wagon is your trust. If there's nothing in the wagon, the trustee is just pulling around an empty wagon. All right. And that's what failing to fund will do to your trust. If you fail to put the things into the wagon, then the trustee's just walking around, you know, pulling an empty wagon, and it's pretty easy to do because there's nothing in there, but it has no effect. Okay. So what we talk about when we talk about funding trusts is we're talking about integrating your plan with your stuff, right? Putting everything together. And the integration is literally putting the stuff into the wagon, right? So you can put box number one, box number two, box number three, and all that kind of fills up the wagon. And now the wagon has much weight, but has weight to it. But because it's all in the wagon, it all moves along the way you've planned it to move along. That's what we talk about when we talk about funding trusts. So specifically, we're talking about transferring assets that require a title to them and putting them and titling them into the name of the trustee and trust so that the asset is now part of that trust document. Okay. So whether that means a deed that needs to be transferred into the trust because you want the property to go to the people you want it to go to upon your death, or whether that's a bank account or a stock certificate or some other asset or a business or an interest in a corporation, all of that needs to be transferred into the trust in order for the trust to have any impact with regards to that asset.
Okay. Yeah, that's a great analogy. I can kind of picture that when you lay it out with the wagon. Does it change anything with the control and ownership that you have of those assets? I mean, I'm guessing that question probably comes up that once you kind of put these into the trust, does it change the way you control them, or do you have to maybe move assets out of bank accounts or whatever else to get them into the trust?
So, okay, it's kind of a two-part question there. So the first question is, does it change anything with regards to the asset? So that really depends a lot on what your actual roadmap is in your trust. But for the most part, as long as you're in control of what's supposed to happen, with the things in your trust, then at the end of the day, how things operate for you shouldn't be different at all. Um, so that's the first thing. Now, with regards to transferring assets and taking things out of accounts, certain banks require that a new account be set up, for example, but the assets themselves do not necessarily need to incur any kind of tax ramifications. They're simply transferred into the ownership of the account is changed.
Okay.
So that's essentially what that would mean.
Okay. So if you are someone that has kind of gone about set up the trust, kind of done some of the paperwork, but has not yet taken that step to fund the trust, and say something happens to you, what ends up happening in that situation if you haven't funded the trust?
Well, so the first thing is that your trust will have no say in what happens to that asset upon your death. So you've kind of defeated the purpose of setting up the trust if the purpose was to avoid probate for that particular asset. So now, either if you have a will, and generally when we prepare trusts, we prepare something called a pour over will that basically takes assets that aren't part of the trust and um, re- although requiring probate, does say the asset would eventually become part of the trust or be transferred in the same way that the trust would say. Or if you don't have a will or a pour over will, it would go subject to your intestate laws or an administration proceeding, which means it may be which may be counterintuitive to your roadmap, right? So if, for example, if you were cutting out a child, or you had very specific wishes, those wishes may not necessarily comport with what the state laws would be with regards to someone who died without a will. So, failing to fund the assets into the trust could basically, frustrate exactly the purpose of what you were doing.
Okay, that makes sense. All right, let's talk about some specifics, or at least assets that people might be moving into a trust, and just kind of give me a breakdown of how you need to actually move these assets or how you fund your trust with these specific assets. And we've kind of touched on a couple of these already, but we'll get to them just a little more detail. I don't need a real step by step, but just basically what does each one of these require? So let's start bank accounts. What do we do to fund your trust with the bank accounts?
So bank accounts are subject to the rules of the respective banks, but essentially it's a change of ownership of the account. So some banks will require you transferring everything over. Some banks will allow you to name your trust as the beneficiary upon your death. So there are a couple of things you can do with regards to that. But each bank has nuanced rules that it applies to the application of trust. Some banks let you keep the same account, just to change the title on the account, and that's fine. So it depends on the particular bank with regards to that.
Okay. Real estate's another big piece of the estate puzzle. What do you have to do with real estate?
So the real estate, the deed has to be transferred into the trust, and the trustees would have to sign acknowledging receipt of the asset, so that it does in fact go into the trust. And that essentially puts everyone on notice that the trust exists, that the trust owns the property, and that in the event of the death of the grantors, that the property would transfer according to the trust.
Okay. Vehicle's another large tangible asset that people will sometimes leave. Do you have to do anything with vehicles?
So vehicles are a little bit. It depends on the state. So some states allow for payable on death, but generally speaking, we recommend putting that into the trust as well if we can, changing the title, changing the ownership at the DMV. Sometimes the ownership can simply be changed on the back of the title itself, and it can be endorsed over. So it really kind of depends on the state.
Okay. Retirement accounts. I know that with retirement accounts, you can't change your ownership of these, I guess, at least while you're alive. So what do you have to do with these?
So in those circumstances, we generally recommend making the trust the beneficiary, so that basically the the impact of your trust remains the same, so that essentially your beneficiaries, as they're spelled out in your trust, will receive the proceeds of the retirement accounts in the manner that you prescribed in your trust.
Okay. A few other here that maybe aren't always as common, but you'll probably see them fairly frequently. Life insurance. What do you do with that?
So at that point, we kind of would either change ownership on the policy, or we would change the beneficiary designation to the trust, depending on the circumstances and what exactly we're looking to do. But we usually evaluate that with our clients prior to doing it.
Okay. Oftentimes people will have brokerage accounts or something of the sort. Is that just a matter again of just changing ownership in those situations when you can do it?
Brokerage accounts tend to be easier to deal with than, say, individual stock certificates. But yes, you
Right.
would sort of treat it the same way you would with a bank. Most brokerage institutions have on their respective websites forms to transfer ownerships of accounts, and that's usually what we would do.
Okay. And then anyone that has maybe company interests, if they have shares of a company, how are you just able to assign those to the trust? Is it a simple process?
Well, it's a similar type of thing. We would do some sort of assignment of the membership interest in an LLC or a corporation, just making sure that it complies with the rules of the shareholders agreement between the shares. That there's multiple shareholders, and make sure that that's done accordingly.
Okay. Very good. So those are some of the main assets that you're probably familiar with, or that you might have in your portfolio that you want to leave to your estate. So some kind of a step by step on each one of those. Now, kind of the final thought here: if you've sat down, like if I'm speaking to anyone listening, if they sat down with their attorney and they've decided, hey, I want to move forward with the trust, and they've done the paperwork and filled that out, but the attorney didn't help them fund the trust, what do you do in that situation?
Well, look, if you're working with an attorney and they're not going to be helping you with that stuff, that really you probably should find another attorney, because that stuff is really half the battle. The documents are important, the planning is important, all of that's important, but it's sort of like, planning for the war and then not putting bullets in the guns. You need the bullets, right? So you need the weaponry. So in this instance, the weaponry is making sure that everything gets transferred over into the trust, because otherwise you haven't done anything. You really haven't done anything. And that's really the most important part.
Gotcha. Well, if you have questions that you want to ask Ted, the best place to start is latticelawfirm.com. You can schedule a consultation there. And for anyone that's considering a trust or wants to move forward with the trust, Ted, what does that process look like? What should they expect from that first kind of interaction with you?
Well, when clients first come in, we sit, we talk about what their intentions are, what their purpose is in either formulating a trust or thinking about formulating a trust, what their overall goals are, and then we sit down and kind of go through the steps, and then follow up with them after we've initially had our conversation and determined a course of action, to map it out, and then eventually get to a point where we prepare documents that fit the plan that they want to set forward, and then once that's completed, we complete the funding process with them.
Very good. Well, if you're ready to create an estate plan that gives you peace of mind, you can request that free consultation online now at latticelawfirm.com, or you can call 718-233-2903. Ted, as always, great to catch up with you, and I enjoyed learning more about trusts and how to fund that. And hopefully we answered some questions today.
I hope so, Ben. Thank you so much.
Thank you for listening to New York's Asset Protection Roundtable, a three pillars of protection program. Please subscribe to this show. I have a new episode coming in a couple of weeks, and we'll talk to you then. Take care.